and our user team. So in the next 3 minutes, we shall be beginning. Thank you.
Welcome to another edition of the 40-something edition of the Judicial Service Conversations. We have been here, but we meet as we always do on these conversations in the humble spirit of inquiry. We have always bemoaned on these spaces the delay that is affecting our courts. As people wait, their wait has become despair. But today, we are going to talk about something else, but something similar: arbitration. And to help us find answers, we are joined by a man of experience and conviction. He is not one of the finest construction lawyers. He is not one of the finest arbitration lawyers. He is, without question, one of the finest lawyers in the Republic of Uganda. Whether you go to the commercial court, the civil division of the High Court, whether you go for arbitration or mediation, wherever you go, you will find Mr. David Kagwa, chairperson of the Chartered Institute of Arbitrators of Uganda, senior partner at the firm Kagwa and Kagwa. He has spent his career building this quiet machinery of justice. And tomorrow he's chairing a conference here in Kampala, the arbitration conference here in Kampala, where people from, I think, all over Africa are coming here to see how we can break down this arbitration. And in the arbitration space, David and many colleagues, I don't want to mention their names, including judicial officers, what they are pushing through in this arbitration space is an attempt to reposition Uganda really as an investment destination. So he is not just a fantastic lawyer, he is not just a very good arbitrator, but he's a very serious patriot. And so, on behalf of the Judicial Service Conversation, and that is the people who are listening, who faithfully endure us Wednesday after Wednesday, on their behalf and on my own behalf, allow me to welcome you, David, to the Judicial Service Conversations. You are more than welcome.
Thank you very much. It's a great pleasure to be here.
Thank you, David. What we will always do when we're here, we start these conversations, and maybe I can just give you a brief background of these conversations. These conversations were born out of our almost endless contest for the position of ULS representative of the Judicial Service Commission. We may need arbitration in that regard, but they have born out of a contest that should have ended on December the 17th of last year. And now we are almost, and we are not wiser coming to December the 17th of this year, and the Judicial Service Commission is sitting without us. But that's an argument for another day. So we started these conversations, and every time we begin these conversations with our guest, we ask them a question that actually many people who have joined want to know. And the question is, who is David Kagwa? Who are you? What makes you tick? What makes your blood boil? Introduce yourself to this audience, and I can tell you, I can introduce the audience to you first. We have an audience of eminent lawyers, many of them listening anonymously. We have an audience of judicial officers, many of them listening anonymously, but many of them also show up here. We have an audience of Ugandans. we have an audience of non-Ugandans. And all of these people from everywhere, assume this is the arbitration conference right now in Mestil. This is it. This is the crowd that you would find there, and many, many more. And we just want to know, Mr. Kagwa, who are you and what makes you tick?
Thank you, Edison. Thank you, Edison. My passion is to create platforms where disputes are avoided or resolved outside the court. So everything I do in my career is geared towards doing exactly that. It is for that very reason, other than being lawyer that litigates most of us, my core passion is to make sure that we have these platforms where relationships are maintained in businesses through because of that I found great pleasure in taking up the leadership of the journalists way back about 5 years ago. We were launched in Uganda. But this institution has existed since 1915. It's comprised of 18,000 professionals in over 140 jurisdictions. But my passion arose from the fact that the countries where arbitration or alternative dispute resolution is prevalent are those countries that are most developed. The countries that are known to be the bedrocks of arbitration in the world, like the United Kingdom, France, Singapore, or even in Africa, Nigeria, Kenya. All these countries have a very strong ADR mechanism. And in all these countries, CIAB is very strong. So there is a correlation between...
What's CIAB?
Chartered Institute of Arbitration, the short form is CIAB. So there's a correlation between alternative dispute resolution and development. So the countries which have a strong ADR mechanism are those countries fully developed. So one of the ways in which we can use the third world is to embrace ADR mechanism. So every single day I work to of ADR mechanism. That's my answer to you, Mr. ELISON.
Wow, if you're just joining us, welcome to Judicial Service Conversations. We are here with Mr. Kagwa, David Kagwa, and he has told us that countries that have developed ADR mechanisms are the ones that are developed. Those that are backward are the ones that have primitive methods of resolution. For example, they have these year-long injunctions that keep people from things. But anyhow, I think one question, and I think you've touched on this, and maybe now we can just go straight into it. There are so many people who are asking, what is arbitration? How is arbitration different from mediation? How is arbitration different from going to court? If someone is listening to you for the first time and he's saying, okay, you guys are Chartered Institute of Arbitrators, but what do you do? Where do you do it? Why do you do it in the dark? Maybe if you could really just give us a bird's eye view and break down an understanding for us common people what arbitration is, and how it's different from, say, mediation or even just going to court. Why can't I just sue patients if I'm not happy?
To answer that question in simple terms, we need to look at the history of arbitration. It was begun by merchants, traders who had disputes, felt that the best way to resolve their disputes is not to go to the court, but to go to a fellow merchant, present their facts to that merchant, and if that merchant made a decision, they would respect it. That way, they will continue their business, they'll maintain their relationships, and they'll continue to grow. It explains why developed countries are what they are. So in simple terms, arbitration is a method of resolving disputes outside the court by referring those disputes to a neutral third party who would decide those disputes. The parties would appoint this third party, or they would authorize an institution to make that appointment, and under that framework, the decision of that neutral third party would be final and binding. So the distinction it has with the court is that with the court you don't have a choice of who the decision maker is. Once you file your plaint and there's a defense, there's a powerful person called a registrar who does an allocation, and wherever your file goes, it's like a dice. That's the decision maker. In arbitration you have a choice of who makes that decision. But also one key element that makes it very unique is that based on the origin that merchants used to go to a fellow merchant, if a construction dispute arises, it cannot be subject to a dice. It must go to a decision maker who is capable and skilled and experienced in construction disputes. So the beauty it has is that you have a specialist who's going to hear your dispute and resolve it. If it's an energy dispute, you'll go to an energy arbitrator who will resolve it. So the uniqueness here is that it comes with expertise. Not all judges are experts in everything. It explains why in certain situations judges call for expert evidence on issues to do with construction, with energy, with tax. Not all judges are as skilled as you, ELISON, to cross-examine on ballistics. So you were able to interpret that book, but not all judicial officers can interpret a book about how guns operate. So what makes arbitration unique is that then you choose the expert to make that decision. So that's one of the major distinctions it has with the courtroom. And then of course the other thing is that because you want to maintain relations and because you may have uniqueness in your business, for example, people who are engaged in businesses that are patented, if there is a battle between tech giants, say Apple and Google, they wouldn't wish to go to a court to file all their documents which have intellectual property that may go out to competitors. So they'll go to an expert to resolve that dispute privately, such that they preserve their intellectual property. That's one of the benefits. And then of course you have the latitude. You can tell this person that we have this dispute, but before you make the entire decision, first tell us who is liable. It's a procedure called bifurcation. So you may have an entire dispute and you bifurcate it into three. So you ask the arbitrator, first decide who is liable. For example, who of us breached the contract, and stop there. So he will listen to the evidence and makes the decision of who is liable. Then you can tell him, determine quantum, how much should the other party pay who is liable, and then you can make a decision on quantum. Then after that they say, okay, based on our conduct, make a decision on who bears the costs. So you've bifurcated an entire dispute into three. So you maintain the power to determine how your case is handled. Many a time when parties ask you to bifurcate and you make a decision on liability, the parties can go outside and resolve their dispute and they continue with their trade. That explains why this process promotes development. Mediation is a process where you get a neutral third party to facilitate a negotiation. The mediator is not a decision maker, but he's somebody who is neutral and trusted by the parties and chosen by the parties to help them facilitate a negotiation. Usually the outcome of a mediation is a settlement agreement. The outcome of an arbitration is an arbitral award, and obviously the outcome of a court is a judgment. That's how I would distinguish the three methods of dispute resolution.
So what's the reach of arbitration if you make a decision that is binding? Because the courts can enforce. If a judge, for example, says that you lose your home, you lose your home. If a judge says that I was going to give an example about law society, but anyway, you get the gist. You get the gist. So basically the question is, when he makes the decision, how is his decision enforceable?
Well, when an arbitrator makes a decision, first of all, not all disputes are arbitrable. The framers of the law in each jurisdiction can restrict certain disputes to the courts only, and there is a reason. Certain disputes that promote public policy at a greater level are restricted to the courts. Some of those disputes involve, like, divorce matters. An arbitrator cannot have jurisdiction to decide a divorce matter, at least in most countries. In certain countries they have allowed arbitrators to do that, but at least in Uganda's jurisdiction, an arbitrator would not make a decision in divorce. An arbitrator would not make a decision about fraud that leads to cancellation of a certificate of title. He wouldn't make a decision regarding rights of children under the Children's Act. And also, our labor law has also restricted arbitration in labor matters. So, to that extent, there are situations when you are appointed and the dispute has a mixture of arbitrable and non-arbitrable items. It may be a sale agreement and you are asked to determine who of the parties breached the agreement. You have jurisdiction. But if the consequence is cancellation of title, then you don't have jurisdiction. So you may make jurisdiction to the extent that you're empowered by law, and then the other part that you are not, which is referred to the court. But in situations which are purely commercial, where an arbitrator has jurisdiction to decide, once a decision has been made, the successful party registers it with the court, and the court's role, once an award has been presented, is basically to determine on the face of it whether it complies with the law. The judge doesn't have jurisdiction to rehear the evidence or to find out whether or not the arbitrator came to the right conclusion regarding assessment of evidence. A judge doesn't have jurisdiction. Their duty is simply to ask themselves whether that decision was procured through a lawful process. So it's more about the process than the merits. So once the judge ticks all the boxes, that the arbitrator was appointed lawfully, that the decision is in accordance with the law, and that both parties were accorded a fair hearing, and that there was due process, and that the matter is arbitrable, obviously, the duty of the court is to enforce that award as a judgment of the court, and the decision of the court is final. It cannot go to the Court of Appeal or the Supreme Court. It's final and enforceable at that level.
Thank you.
Yeah.
But when you mentioned thank you, Councillor David. Yeah, as Mr. Edson says, you are already firing from all cylinders. But as you mentioned, when you introduced him, the catchword was that with arbitration, you have the power to determine how your case is going to be handled. And my question comes from that. I'm sure without courts and our cases, every Ugandan would want to have that power to maintain how his case is handled. So now bringing it practically in Ugandan context, who actually uses arbitration, and is it mainly for the rich, for the big corporates, or can ordinary people and small business owners also benefit from it? Because there are scenarios where even the person tells you, for such a contract involving small amounts, don't even include arbitration clause. So it leaves me wondering which people can use arbitration to resolve their disputes. Thank you.
Thank you for that question. Very good question. And I must admit that the cost of having a competent, experienced lawyer on the face of it, can be a significant cost. So if you're going to have an arbitrator who is a specialist in oil and gas or power or mining, they will not come cheaply. In certain arbitrations under the International Chamber of Commerce, arbitrators are paid almost between $100,000 to $300,000, which is quite high. So as a matter of fact, arbitration, as far as arbitrators' fees are concerned, it may be more desirable for high-value disputes. So it may not be very desirable for smaller claims. But then also, those high-value disputes, if you look at it from the perspective of value, if a person has a mine and they had invested up to $100 million, it will not be an issue for them to pay $100,000 in arbitration fees because of the magnitude of the investment that they had put in. They would rather pay $100,000 and have their decision within 6 months than go to court, pay filing fees of say maybe 10 million shillings, and then wait through the entire court process. There is actually a particular case that I filed in 2008.
I know that case.
And we've just reached the Supreme Court. So the High Court made a decision, Court of Appeal made a decision this year, and the Supreme Court, we've just filed the Memorandum of Appeal. But in essence, from 2008 to now, it's a period of almost 17 years. So we're still at the Supreme Court, which may take maybe another 4 or 5 years. So everything else that we've been fighting for has lost commercial sense. So you rather pay $200,000, get a decision in 6 months, and move on.
That's the follow-up question, because when you see it's more like a result of those commercial vehicles, then that means another question: how can you make it maybe more suitable for the ordinary Ugandan? Because as I said, everyone would want to have that power to determine how this is done, but then because of the income shortfalls, not everyone can have that power. Then we want to make it more simple for ordinary Ugandans, and then even the ordinary young lawyer would want to practice arbitration as a declaration practitioner. Sorry, even the ordinary young lawyer would want to be an arbitration practitioner, but the costs for the training seem to be also way above. So it's like it's segregating somehow. Thank you.
By the time you go through law school, you don't fall within the category of an indigent. You can definitely afford to pay $400 to do the associate course of the Chartered Institute of Arbitrators because it grows your career. But regarding your question, it was a very good question. How do we make arbitration affordable? It's a very good question. One of the ways is in many of these countries, like Nigeria, for example, they have 12,000 CIAB members. Those are arbitrators who have gone through the training, who are certified. They have 12,000. And maybe it explains why they have the biggest GDP in Africa.
Double the Uganda Law Society.
Yes. So basically, that's why there's a correlation between people who use ADR and development. Now, a country like Kenya, I think they're about 1,500. They've been around for 40 years. So if you have 1,500 members of the Uganda Society as members of the Chartered Institute of Arbitrators, it means that the disputes that happen amongst them, they're most likely to call each other to resolve them amicably. 5 years ago, we were about 9 members of CIAB, 1 to 9. The rest of us of Uganda Society were gladiators. Whenever you get instructions, you want to fight, because that's what we're trained to do.
So if we grow this number significantly, which is one of the things that makes me wake up every morning, if we can grow this number to at least 10,000, because we are now 250, but 5 years ago we're 9, so we're now 250. So if we can grow it to 10,000, because we have about maybe 8,000 members of Uganda Law Society, but CIAB is not about lawyers only. If we have the engineers on board, the architects on board, the valuers on board, and the surveyors on board, and we have 10,000, it means the disputes that will arise and 10,000 people have to advise on them are most likely to be resolved amicably. They will not go to the court, so the court will not have issues with backlog. So it has a great deal to do with our culture and how we deal with disputes. Research showed that countries like Singapore, almost 98% of all their disputes are resolved through alternatives to the court. It's only 2% of their disputes that are taken to the court mainly for enforcement or setting aside all those disputes that are not arbitrable. And it explains why Singapore is in the first world and we're in the third world, yet Uganda and Singapore were in the third world in 1964. So we're together, we're buddies. Now, so many years down the road, we're still in the third world. These guys are in the first world because their culture is about dispute resolution amicably outside the court. Our culture is, it's time to draw the sword whenever someone draws a sword. So what we can do is, if we draw our numbers to 10,000, we can create tiers. And we say, okay, arbitrators below 5 years experience, you should be maybe able to charge arbitration fees of say 5 million shillings. Then it will be affordable to those merchants who have low value disputes. Then those arbitrators who have up to 15 years experience can have their fees maybe up to 15 million. And then those with experience maybe above 15 onward, 15 maybe to 25, can charge maybe 30 million. And then those who are specialists can charge based on the extent of the dispute. So maybe that way we can make it affordable if we break it into tiers. Yeah.
Thank you very much, Mr. Kagwa, for joining us, and for the people in the audience as we discuss navigating the frontiers, arbitration in Africa's evolving landscape. Thank you for being a part of us, and remember to pass on the link. We're also live on YouTube and TikTok, so keep the link going. Now, the conversation is quite interesting, and for the young lawyer, I think you have had your shot. Save that 400K and go, and what is your excuse? Mr. Kagwa, I think you've mentioned something to do with arbitration helping to reduce backlog. And so in terms of access to justice, I think the question now is, do you think arbitration is actually helping to reduce court backlog, or is it becoming a way of some escape from the formal justice system? Because I think you've mentioned that what they get is an arbitral award. So what happens to the perpetrators, where maybe there would be some sort of a punishment or something in court? What happens this side of arbitration? Thank you.
The decision of an arbitrator, once enforced by a court, is as good as a court decision. So if there is a decision that says you need to pay 100 million shillings plus costs, just like a judge would have ordered that, the orders of the arbitrator are enforced just like the orders of the court, because under section 36 of the Arbitration and Conciliation Act, it provides that once an award has been enforced, it becomes a decree of the court. So you can enforce it in any way as a decree of a court. So they're at the same level, almost at the same time. But an arbitral award that has been converted into a decree is actually more advantageous than a decision of a judge, because it's final. A decree of the High Court, there are still 2 tiers to go: the Court of Appeal and the Supreme Court. But a decision that arises out of the Arbitration and Conciliation Act has the High Court as the final step.
We have, if you're just joining us, welcome to the Judicial Service Conversations. We are having Mr. David Kagwa here. Please, I hope you're learning and enjoying and understanding this new area which we have not discussed here, arbitration. And our next question is going to be asked by a new guest host, herself an arbitrator. I'm sure she's in the top tier of specialist arbitrators, not the ones you are proposing for 5 million, but please, Patience, over to you. Welcome to the Judicial Service Conversations yourself. Thank you for being our guest host today and for taking the time to come here, especially on a subject of such important and wonderful magnitude. And if you're just joining us, welcome, of course, to this Parliament of the Bar.
Thank you, ELISON, for having me. Good evening, good morning to the rest of the members on the call. I must say this is a very interesting discussion, and I am glad that it's happening at the time that it is happening, and I believe our listeners are likely to get a lot of insights and impact from this. David, my question to you is in respect of what role can a lawyer play? In the introductions, ELISON said you're a seasoned lawyer, a litigator, and you're the chairperson of CIAB Uganda. So briefly, could you tell us, one, what skills or qualifications are needed for a lawyer to be an adjudicator? Or is it that any lawyer, regardless of their number of years of practice, experience, or expertise, can be an adjudicator?
But maybe just before David comes in, I've received a request. Someone here wants to know, Patience, who are you and what makes you tick? The same question we had asked David, and then you could kindly repeat your question again for David.
Okay. One, I am a lawyer by profession. I happen to work at one of the, I would say, the best law firms in Uganda. What makes me tick and who am I? I believe in creating a difference and going outside the normal. And for me, when I say outside the normal, I look at arbitration as outside the normal because we are very used to court as the immediate resolution mechanism that we go to. So what makes me tick is to how can we resolve disputes in other ways besides court? And for me, the disputes I would say I'm more interested in are, for example, construction disputes. David mentioned that ADR mechanisms contribute highly to the development of a country. And over time, we have seen how the infrastructure in Uganda has grown. And we all know almost all contracts to do with infrastructure have arbitration. So for me, it's how do we use these alternative mechanisms to resolve such unique disputes. So Patience is a lawyer who has keen interest in construction law and arbitration, and I like to see other people join the space.
Okay, thank you. And now your question.
So going back to my question, you were said to be a seasoned litigator. You like to call them gladiators, but I believe now more you're an arbitrator than a gladiator. My question is, can any lawyer, regardless of their number of years in practice or expertise, become an arbitrator? Or are there specific skills that they need to have to make them an arbitrator? And I would like to say not just any arbitrator, because you said at least there's a possibility of having tiers. So if you want to be in the tier that gets most of the thousands of dollars, you'd have more qualifications or the requirements that are needed. So briefly, could you tell us what those would look like?
Thank you, Patience. Any lawyer or professional can actually be an arbitrator. We all know that magistrates join the bench straight from LDC with not much experience, but they render judgments. And sometimes people struggle to reverse those judgments even at the high court level. Yeah? So anybody can actually, any professional can actually be an arbitrator. So it's just a question, but it's necessary that you go through the training. The Chartered Institute of Arbitrators is the gold standard for arbitration training. It's a prerequisite before you join arbitral panels all over the world that you must have a qualification from the Chartered Institute of Arbitrators. So once you have that training, at least you'll have two benefits. One, you'll have the knowledge and skill to be an arbitrator, but most importantly, you are bound by a code of conduct to conduct yourself in an ethical way. So every year as we renew our membership, you sign an undertaking that you will abide by the ethics and the code of conduct of the Chartered Institute of Arbitrators. So that way we maintain professionalism through every work that we do.
David, thank you very much. I have a follow-up question. You said anyone can be an arbitrator. So would I be correct to say that arbitrators are not only lawyers, but also other professions? If they get the necessary training, they can also perform the role of an arbitrator?
Absolutely. Any professional can play the role of an arbitrator. But the caveat is, whoever is going to appoint the arbitrator, or the parties, they need to be mindful of the nature of dispute. If a dispute significantly involves interpretation of contracts, where one party is alleging that there was ambiguity in the clause, and therefore the decision maker must apply the contra proferentum rule, you can't give it to a surveyor. So decisions that involve significant contractual interpretation, give it to arbitrators who are experienced in law. Decisions that involve decisions about structural integrity of buildings, give it to an experienced engineer. The decisions that involve quantities, whether or not the bills of quantities were in accordance with the specifications, give it to a quantity surveyor. So it's very, very critical that an arbitrator is not a jack of all trades. Give it to the one that is most suitable to resolve the dispute.
If you're joining us, welcome to the Judicial Service Conversations, and we are here with Mr. David Kagwa, firing on all cylinders and taking us through the rigors of arbitration. If you did not understand what the contra proferentum rule is, I'm sure then you're not a member of the Uganda Law Society, but just speak to a lawyer near you and you will have a proper understanding of the contra proferentum rule. And it is only here on the Judicial Service Conversations that you will hear of the contra proferentum rule. Over to you, Alfred.
Thank you, Mr. David, for that clarity on who can be an arbitrator. Some young lawyer here said, thank you for this free sale event. Sorry. You know, I think I'm upset because I'm within rich people. This arbitrator. But I'm not back. So thank you, Mr. David, and for that clarity. The young lawyer was saying thank you for this free sale event, but again, there's another one who is pending joining LDC is now saying, even if I fail PN2 exams, I'll go and start training to be to be an arbitrator, because instead of waiting to see what the way forward. But
there's no arbitration for divorce.
This is not a family practitioner, so you'll handle. Anyway, going now looking at a big picture for a moment, I just want us to compare how strong arbitration is in Uganda today as compared to other dispute resolution mechanisms like mediation or traditional court trials. From where you stand, are we seeing more people and institution is choosing arbitration, or still litigation and arbitration still take the lead, even with a bit of more sensitization from CIAB, which you have led with those numbers from 9 up to now 250 practitioners, as you're looking forward to 10,000 and more. Just that big picture in general, and whatever picture will portray, what does it tell about how Ugandans are confident in arbitration or the normal formal justice system? Thank you.
There's definitely been a growth, and I cannot emphasize it more that there is a correlation. It's like Newton's third law of motion. For every action, there is an equal but opposite reaction. So for every action of development, there is an equal and opposite reaction that arbitration will grow. And the reverse is true. For those countries that are in the third world, there is an equal opposite reaction that they resolve their disputes either through violence or through the very long process of the courts. I can give an example of our neighbor South Sudan. There cannot be an international arbitral panel comfortably lying, seated there deciding a dispute as bullets are flying. So basically you need development in a peaceful setup, because capital is shy. Capital goes to those jurisdictions which have peace, which have efficient mechanisms of enforcement of contracts, and which have governments and entities that will respect the outcome of awards. So, in as much as the most common method of dispute resolution is the courts, it's mainly to do with our culture. When we are taught at university, I went to Makerere University, you are taught to argue your case. There is no course unit on dispute avoidance. Yeah. So, but now the world has moved away from dispute resolution to dispute avoidance. So, for those contracts of high value, most especially infrastructure projects, they all have arbitration clauses, and they emphasize dispute avoidance as a first step before going to resolution. So the world has moved away from gladiators. The new generational lawyer is that one with soft skills that will avoid disputes, or when they arise, to resolve them.
Thank you. That thing that the world is moving away from gladiators after introducing you as a legal gladiator handling with disputes. I think that the world is moving away from you, but still you're moving with it at the same time.
No, I saw the light. I don't litigate as much as I litigated 15 years ago.
Yes. Thank you then for bringing the light to us. Yes. Then maybe with your perspective, from your comment, what do you think will be the driving trend to drive arbitration more in Uganda, so that it comes? I know Uganda, I don't know if I can say a third world country or not, but at least it is bit secure for arbitrators to sit here. But from your perspective, what would be the driving trend to have more arbitration practice in Uganda?
I'll give a simple analogy. This analogy is very common with land speculators. I'll give an analogy of land speculators. They can predict, I don't know from where, that certain roads are going to be tarmacked. Then they go and buy small pieces of land. Some of them even buy where the road is going to pass. So by the time the government comes to look for the project affected persons, they find people with very high balance sheets as the project affected persons, and then they're the ones that are compensated. So it is so the principle is, you either go to those places before the development comes, that's when you can afford them, or if you wait for the development to come, then you will not afford. So all this information is available for us to see, and let me give you the facts. The World Bank and African Development Bank are the leading lenders to African governments for infrastructure projects. The number of roads in Imbale, there is a road that goes to Budadiri, there is even the Kampala flyover, it was sponsored by JICA, the Busega Mpigi Highway, African Development Bank. So all these projects which are funded by international development banks, they are governed by the FIDI conditions of contract, because the lenders insist that those are the contracts that should govern.
What are the FIDI conditions of contract for?
The FIDI conditions of contract are a standard construction contract which is published by the International Federation of Consulting Engineers. It's based in Geneva, Switzerland. These standard contracts have been used for over 100 years globally. So the best standard for construction contracts. So these development agencies signed non-exclusive contracts with FIDIC to use them wherever they lend their money. And it's based on the principle of he who pays the piper calls the shots. So they come with their money and they say, we're going to finance this road, but it must be administered by a FIDIC contract. Now what that means is that there will be an arbitration clause, there will be an adjudication clause, there will be mediation done by the engineer. So in essence, just by virtue of us adopting the FIDIC contracts, ADR has automatically been adopted. So we need to ask ourselves, aren't we better off getting the skills now before the road reaches, or we wait for the road to reach? Then we won't afford. So we very well know that there is a plan by the government of Uganda to grow our GDP tenfold. So right now our GDP is almost $60 billion. So it is intended that maybe in the next 10 years it will be maybe 500 billion. If our GDP has gone to that level, so you can imagine the amount of infrastructure development and the amount of business that will arise out of disputes which will not go to court. So it's a question of having the capacity to predict where we are going, and then we get the necessary skills to enable us sail along the way.
Thank you, Mr. Kagwa, for that. Now, I think my question is going to be from the mind of a young lawyer that is listening, and also from the, as we're learning more and more from the judicial service conversations, we're realizing, and some of them are right here in the room, realizing that there's what you get in law school and at LDC, and then kuground bidala muko, you know. And some people who are in practice, maybe at the entry levels, are mostly making money from, you know, adjourning, because every time you're going to court, you're getting an allowance. So that is how money is coming in for them. And some also, they have this illusion that, I think it is an illusion, really, that for as long as you're done with your law degree, you have the bar, you have enrolled, then automatically money is going to start flowing, and then they get in and they're disappointed. And I think there's that perspective that is, every time they think of arbitration, that is what comes in their mind, that, okay, so we're just going to sit, disputes are resolved, how is the money being made? And so I think maybe, could you enlighten or educate us or inform us actually on, I know that there are pros and cons of, you know, choosing arbitration, and some you've hinted on them, but what are some of those challenges? And for a young lawyer sitting at the edge of the fence and not sure whether to just go in or just stay this side and wing it, what are some of those things that you would say to them that should actually push them to consider arbitration? I think it's been wide, but I just needed to give you a background, and maybe it's about why a young lawyer should get themselves interested in joining or going for arbitration. Thank you.
It's the way to go. It's like asking a question, should I learn It's like asking the question,
You're muted.
It's like asking the question, whether, it's like asking the question of, should I use AI, artificial intelligence, or I continue doing things the way. The world will not wait for you. If there's artificial intelligence, you just have to adopt to it. because then you will not be efficient. So it's the same thing. The world has moved away from resolving disputes through the courts. Commercial disputes should not be resolved through the courts. The courts should be, their role is to assist the arbitral process. In the United Kingdom, there is a TCC court, the Technology and Construction Court. Its role is basically to enforce adjudication decisions. So because they have an act that provides that every infrastructure construction project, once there's a dispute, it shall first go before an adjudicator. So even if there is no clause in the contract, it's statutory adjudication. And when an adjudicator makes a decision, within 28 days, that court exists to enforce those decisions. Their level of enforcement is almost 80%. So if we are going to develop and rely on foreign direct investment, investors are not going to line up in our courts. They want that we have an efficient method of resolving disputes. The conversation we should be having is, how do we engage with government to enact the Construction Act, to allow quick resolution of infrastructure disputes? There is no reason why an infrastructure dispute should go to the court and spend there 15 years. This will the following will happen. One, the project won't be finished. Number two, the contractor most likely will become bankrupt. Number three, the people who were intended to be served, like that road in Imbale that goes to Budadiri, is intended to promote quick transportation of coffee from the farmers in Budadiri to the city centers. So it is intended to grow the economy in Imbale. So if there is no mechanism of resolving a simple dispute like payment of a contractor, the road will not be finished, the Imbale people will remain poor, the contractor will become bankrupt, subcontractors won't be paid, lawyers won't be paid. So the conversation we should be having is, we should not reinvent the wheel. How have developed countries arranged themselves such that they are efficient? Which laws have they enacted? They have the Construction Act. In Kenya, CIAB in Kenya has lobbied, and they are going to pass the Construction Act. So when you ask yourself, why is Kenya's GDP bigger than ours? Because the method in which they enforce contracts is more efficient than ours. So we need to move ahead of the times.
Thank you, David. Going back to what you've just spoken about, the laws that are being adopted or the changes that have been made in other countries like our neighbor Kenya. My question to you is in regard to courts and politics, but I'm going to start with politics. You said that capital is shy and it does not like chaos. So what role do politics play in either influencing the growth or the decline or the credibility of arbitration in Uganda as an alternative dispute resolution mechanism?
Patience, that's the toughest question I've received, because I'm not a politician. But to put it simply, when parties are choosing, when parties are negotiating contracts, one of the most critical clauses that they negotiate is the dispute resolution clause. Now that clause has sub-clauses. One of the sub-clauses is, you agree on the method of dispute resolution. You can say, we shall first negotiate, then mediate, then arbitrate. That's the tiered clause. The other sub-clause that you would negotiate is the law of the contract. You can say the laws of Uganda will apply. The other thing you will negotiate is the language of the proceedings shall be English. The other thing you will negotiate about is the seat. The seat means the legal jurisdiction to which that arbitration is anchored. In simple terms, you can have the seat as London without stepping there. But what that means is, if either party needs to enforce that award, they would have to go to the seat of arbitration. Or if either party wants to set aside that award, then you have to go to the seat of arbitration. So it is the legal jurisdiction to which that arbitration is anchored. But one critical decision that the parties make is the venue. So there's a difference between seat, which is the legal jurisdiction, and the venue. So you can actually have the seat as London and the venue Serena Hotel, Turako. So all proceedings take place here. So the question is, to all our members listening, who would choose the venue of Somalia? So that's the effect of politics on development. It is very critical that it's only those countries that have peace, that have efficient methods of resolving disputes, that have conducive laws for business people, that people will choose to come to our countries. Tomorrow at the conference, we have more than 200 delegates coming from all over the world. They wouldn't come to Kampala if there were riots on the street. They're in Kampala because they've come to enjoy our infrastructure, our environment, and to also interact with us, to give us business, and also to look for business. But also, they're going to visit our game parks. They're bringing foreign currency, and most likely they'll encourage their clients to set up branches in Uganda. So it's very critical on the political perspective that we have a conducive and peaceful environment to grow business in order for arbitration to thrive.
If you're just joining us, welcome to the Judicial Service Conversations. We're having a fascinating conversation where we're hearing that investors are not going to line up in our courts. We're hearing that developed countries, how have they organized themselves to develop? We're hearing that capital is a coward. It only goes where it grows. We are firing on all cylinders. You can only have this conversation on the Judicial Service Conversations, the Parliament of the Bar. So if you're joining us, you're welcome, and please listen. Over to you, Alfred.
Thank you, Mr. Kagwa.
Oh, sorry.
For the record, I'm not Alfred.
No, you forgive me.
My other question, which is similar to politics and their effect they have on arbitration, is to do with courts. 5 years ago, there were only 5 registered CARB members. Now they have grown. So my question is, what role have Ugandan courts played in influencing the growth of arbitration or the decline thereof, if that is the case? Because, like Joy said, people have the misconception that the longer I stay in court, the more money I'm earning, however little or big it is. And you have your matter, which has been in court since 2008. So briefly, what role do courts play? And also, how better can they promote arbitration?
First of all, I want to deal with the last part. It is a misconception that the longer you stay in court, the more money you make. I have not made that money by staying in court for 17 years for that case that I am handling at the Supreme Court. I was paid in 2008. I even don't know where I put that money. So it's a very wrong misconception that the longer you stay in court, the more money you make. Of course, there are certain ingenious lawyers who charge clients that every time they go to court, they're given, maybe 50,000 every time they go to court. So they assume that if the case takes 3 years, you keep on earning 50. Now you need to make a choice, whether you're a retailer or a wholesaler. If you're going to be dealing in matchsticks and nails, you continue collecting. But the problem with that collection is that then you become an undertaker. On Sunday, when you call your client asking for 50K, you become a problem. Whenever he sees your phone, it's like, this guy now wants 50k. So it is a misconception. You make money by resolving your disputes quickly.
Correct.
So let me go to your question.
Thank you. Going back to our question, it's indeed a misconception, because how can you be a retailer if there are better opportunities for you to make killings and killings in money? So what would you say the role Ugandan courts have played in promoting the growth of arbitration or the decline, if that is the case? But also, if you're to compare it, let's say, with the other courts in, for example, our neighbor, Kenya, or Nigeria, which has a bigger GDP than ours, how have the courts of Uganda promoted the growth of arbitration? Thank you.
Thank you. That's a very good question. Thank you, Patience. The courts in Uganda have played a very big role in promoting arbitration. I've been following decisions of the courts right from 1997 to date. The courts have played a very big role, and our act specific. We have Section 9 of the Abitration and Conciliation Act. It provides that no court shall interfere in matters governed by the Act, save as expressly provided for in the Act. So then that means you need to go to other provisions of the Act that provide where a court can intervene. It intervenes in cases of injunctions to protect the status quo pending arbitration. It also intervenes in cases of setting aside awards
Good at injunctions,
and enforcement of awards. I'm not talking about injunctions from the civil division. I'm talking about injunctions from the commercial court that are intended to preserve the arbitration process. Those are the ones that I mean. So it has played a very big role. Right from certain decisions that went to the Supreme Court, I think there was Babcon versus Mbale Resort, where the court emphasized Section 9 and actually said that an arbitration clause ousted the jurisdiction of courts to decide the dispute. So the judges at the commercial court now, if you file a case and it has an arbitration clause, 99.9% they will actually strike out that suit and refer it to arbitration. So we've received a lot of support from the court, and I commend them. And we are deliberately engaging the judiciary. At tomorrow's conference, we have a specific panel on the role of ADR and the courts. And we have distinguished members of the judiciary. We have Justice Chiriawire, we have Justice Mobiru, we have Lady Justice Henrietta Wolayo. We had invited Justice Harriet Magala. She's a champion for mediation. So they have played a very big role, just to answer you, and arbitration cannot exist without the support of the courts.
Okay, now, if you're just joining us, we shall say over to you, Patience.
We have now interchanged the names. Anyway, when you said that you either choose to be a retailer or a seller, someone said, "Only cover those people who charge me." So, but now talking of the conference tomorrow, when you talked of 200 delegates, my mind was like, is this another program experience which we are about to have tomorrow? But now let's now talk at that big event. I first learned about that conference, I think, 1 month and 2 weeks back. I was engaging with the Alexander Senskombi, is the chairperson for Young Arbitrators, secretary, Young Arbitrators Pact, and he was my farm leader at LDC, so he keeps inviting me to do things, but after inviting me, mention his dollars, I'm like, but am I the target market? I'm the retailer now. They are talking about. And that time was talking in dollars, but now I think they have converted the dollars to the shillings, which we understand of 1 million for the 2 days conference. So a person out there is wondering why should attend the conference? What should the public and the lawyers or practitioners expect from this conference? And maybe more importantly, why is having this conference at this time timely and critical for Ugandans right now, both the business community and the ordinary citizens who might one day need to resolve disputes efficiently? Thank you. Okay, yeah. Sorry. Just rephrase my question again. Talking of the International Arbitration Conference happening tomorrow, and you said already 200 guests are coming on board. It's like another Chogam experience. So the listener here, the person who has been seeing the flyers, is wondering why he should attend that conference, and what he or should expect from the conference, what should the public or the practitioners expect from the conference, and maybe more importantly on a broader perspective, why is having this International Arbitration Conference timely and critical for Uganda right now, both the business community and ordinary citizens who might one day need to resolve disputes using arbitration?
Thank you very much. The main reason why this conference is important to attend, first of all, is to get knowledge. There are so many facts, and it's not about Uganda. It's an international conference. So it is intended to grow our expertise and knowledge and business worldwide. We are now a global village. If you're an arbitrator in Uganda, you are capable of being appointed in South Africa to resolve a dispute. But people appoint only those that they know. So when you attend this conference and you interact with the professionals from all over the world, they get to know that this is Mr. ELISON KARUGANGA. He's an expert in oil and gas and ballistics. And that, and that when there's an opportunity, they will appoint you to go to Singapore and resolve a dispute. So it's an opportunity for professionals to grow their career. That's number one. Number two, there are a lot of facts that we know about Africa, but we've never thought about how to demystify those facts. Let me give you one of the facts. Demographically, Africa has one of the largest populations of the youth under 25 years old, 25 years, globally. So we know that fact, but what does it mean? And this is what it means. It means that our schools are overcrowded, which means there are opportunities to build more schools to take care of this growing youth. But at a higher level, we have more than 50 universities. When I was in law school with Mr. KARUGANGA, I think there were like 2 or 3 universities. This is not to mean that he's a dinosaur, but he's still a young man. But now there are over 50 universities. So, and these universities are full. So what does that mean? It means that there is a growing demand for student accommodation. The universities cannot accommodate students even in the halls of residence, so they have to be hostels. The hostels are full. So now there is a great opportunity for the construction of student hostels. So next year, one of the top universities is going to sign a public-private partnership agreement with an international contractor to build student hostels worth $100 million in Uganda. So where will you find such information, such that you position yourself to either be an advisor or an arbitrator or an adjudicator? You need to come to these conferences to get these facts. And then other universities are going to follow suit, just to sort out the question of student accommodation. We can still look at other facts. For example, Africa is the most unbanked continent. Let me give you a simple statistic. We are about 46 million Ugandans, almost 15 million Ugandans. If you went and you check the statistics of how many bank accounts we have in the 25 banks we have, there are about 4 million bank accounts. But Mr. KARUGANGA alone has like 10 bank accounts. So now they've even counted him 10 times. So it shows you that almost 80% of Uganda's population is unbanked. But what does that mean? it means it created an opportunity for mobile money to grow. And now people are borrowing from mobile money. Sometimes people tell you, don't send me mobile money, Bamanja, because he has borrowed. So the mobile money business has grown by virtue of us being unbanked. So it's an opportunity for technology firms to take up spaces. And there's a lot of things. There's the African Continental Trade Area that has created a block, the largest commercial block in the world, with a combined GDP of $3.5 trillion. It's only in Africa. So we are no longer now looking at doing business or practicing our professions within the confines of Uganda. You have capacity to go and practice as an arbitrator in Algeria, in Morocco, in South Africa. And just to add more to that, the construction projects that are coming up all over Africa require the establishment of dispute boards. Dispute boards are a group of 1 or 3 professionals that are appointed at the commencement of the project to assist the parties to avoid or resolve disputes. So they are being appointed all over the world. But if there is a hydropower project in Ethiopia, usually the parties may not want that the dispute board members come from Ethiopia. So they want one member from Uganda, another one from Kenya, another one from Tanzania, to avoid the bias of origin of countries. So how will you know that there is a dispute board to be appointed in Zambia unless you are in such fora? So that's why it's very critical that the 2-day conference that brings professionals from over the world is attended, such that you're able to see these opportunities that are right in our faces.
Thank you. Thank you, David, if you're just joining us. You're joining the Judicial Service Conversations. This is the Kasiki of the conference.
Yes.
At the conference you can find the real deal, but here you can find the bird's eye view. We're happy to be the Kasiki of the conference because this, as we've been telling people, this is the parliament of the bar, the Judicial Service Conversations. And I think that really brings us to our next question. I think this question is the future. If we're now to put ourselves in the future, technology, artificial intelligence, how is it, because the world is now different. Because every day that passes, the world is now different. I remember once telling a group of lawyers, I can see Tony Kalandi here. I remember telling a group of lawyers under his chairmanship, I was asked about technology, and I was saying it's like we are back at the time when the printing press was being formed, and the way that writing changed the world. Technology now is a serious game changer. How would you say that technology and AI are shaping the future of arbitration in Africa and in Uganda? What's your take on that?
Thank you, ELISON, for that question. And I'll answer it with a simple analogy. There is a difference between a puzzle and a mystery. A puzzle is when you lack information and you only look for one piece to complete the puzzle, and that's it. A mystery is when you have a lot of information but you cannot gather what it means. So in simple terms, there was a man who invented antibiotics, I think in 1928. A very wise man, because many people were dying. I think he was called Fleming, and he invented penicillin. So when you go to a doctor, he draws blood, then he puts it in a machine, and then the machine says bacteria. That's the puzzle solved. But the mystery is, where is the source of the bacteria? Is it in the throat? So a doctor removes the torch and puts to see whether the source is a sore throat or it's in the stomach. So the first part of the puzzle is there's a bacterial infection. That one artificial intelligence can do. But AI cannot resolve mysteries. So, the practice that I do most, which is construction, is if you went to ChatGPT and you put facts in ChatGPT, it will tell you with accuracy that the contractor is in breach. He's in breach by 20 days and he's liable in $50,000. Those are puzzles. But the mystery is, this is a road that goes to Budadiri. You are a dispute board member. The government of Uganda wants this road ready before 2026. Imposing penalties on this contractor, he's going to run away. So you need to have soft skills to tell the employer that, look, whereas according to the puzzle you're entitled to $10,000, but the road won't get finished. So as a win-win situation, can you waive your right to delay damages? Let the contractor finish the road. We need it in 2026. The donors need it, so they give us more money. So it takes a human being to resolve mystery, but AI resolves puzzles.
Thank you. We are firing through on the judicial service conversations, and I can assure you that I know of a puzzle which is a mystery, but I will not get into it here. So David, here on the judicial service conversations, we've been for almost a year now banging on about backlog in the formal court system, and backlog is growing. According to the judiciary, backlog is cases that have been there for 2 years. That's a very arbitrary definition. We had here the Tax Appeals Tribunal, and the Tax Appeals Tribunal told us that for them, they think backlog is when a case has been unresolved for 9 months, and their idea is that it must be a moving target. It used to be 11 months, it is now 9 months. They plan to make it 6 months. We had here the donors, the head of the justice support, I forget the name it was called, the justice support, the chairperson of the donors, the Austrian embassy here, and they told us that we don't understand why backlog is 2 years. Where is that definition? But nonetheless, backlog at 2 years has grown last year from 42,000 to 46,000. The judiciary, to be fair, has done a lot to fight backlog, results notwithstanding. Last year alone, they invested 50 billion shillings more into the judiciary. The government has put 120% increment in the judiciary's budget, from about almost 190 billion just 3 years ago to about 450 billion today. Uganda has more judges than it has ever had, more court buildings than it has ever had, more technology deployed in the courts than it has ever had, and the backlog in real terms goes up. Meanwhile, the ability of the courts to resolve disputes actually has gone down as a percentage number. I think from they resolved 58% of disputes last year and 57% this year, according to the recent Chief Justice report. So, in our view, one of the largest, the commercial court, the PS of the judiciary told us that the commercial court is holding, at least 2 years ago, we don't have the statistics down, but 2 years ago he said the commercial court was holding about 44 trillion shillings in disputes, which was more money than was available in the banking system being lent in the country. More money is stuck in the court, and then within the banking system itself, more than I think 30% of the banking system is stuck in court in banking disputes. So the cost of borrowing is therefore high. You talk about infrastructure projects. The cost of infrastructure projects is actually high, I think, in Uganda and Kenya than it is in Ethiopia, simply on account of backlog. As an actual, the Bank of Uganda told us that as an actual cost issue, one of the big cost issues in the cost of money in the country is actually backlog. We've had, for us, backlog is the serious crisis of our time, because even in the criminal justice sector, people are waiting 7 years on remand. Someone 28 years famously. But the average, according to the recent judiciary report, if you are taken to jail and falsely accused of a crime that requires a High Court judge, you will spend 2 years on remand. So 2 years is right now a standard time. I know of a case, maybe I was going to say I'm involved, but no, I know of a case. I know of a case where a government lawyer told an accused person that you've had a very, you've been, this is one of the fastest trials in Uganda, and the person said, how fast is my trial? I said 2 years. So 2 years is remand. Now, what we've been advocating here is mission-based judges. That's what we call them. And we anchor this on Article 142.2 of the Constitution. And Article 142.2 of the Constitution simply says, in our view, not in our view, it says that where there is a vacancy in the court, where the court is, a judge is unable to perform the functions of his office, for example, he has COVID, yeah, or he got an accident, so there is no vacancy, but the judge is unable to perform the functions of his office. Say there's a pandemic and all of the judges are unable to perform the functions of their office, or where the state of the business of the court so requires. The President may, acting on the advice of the Judicial Service Commission, appoint someone qualified to act as a judge for a period. So for a very limited period, you get in there, and our idea is very simple, mission-based. We say we are clearing backlog. You get in there and you say the average time it costs a land dispute in this country is 7 to 10 years. What happens if you take my land, for example, yeah, and I don't, and you think I'm going to wait for 7 years? I'm going to cut your stuff down. You know what that becomes? Malicious damage to property. You know what that becomes? Crime. When you cut my stuff down, I'm going to beat you up. You know what that becomes? Assault occasioning grievous bodily harm. Before you know it, there's a village problem. Before you know it, there are offenses even under the Witchcraft Act. Now, all of this is happening because of backlog. We've been proposing mission-based judges. Now you're talking about arbitrators, and you're talking about 5 arbitrators becoming 250 arbitrators. Many lawyers are already arbitrators. If only 5 years ago you were 5 people qualified from the Chartered Institute of Arbitrators in this country, 5, and now you've grown to 250, that is without a doubt one of the most significant growth levels, and lawyers, I think, are a substantial number of that 250. Yes. Do you think that the arbitration is like the real, even for all these non-arbitrable matters, do you think that the growing success of arbitration, if you look at the arbitral disputes which are being resolved, the value of them, the pace at which they are being resolved, the amounts that are actually being resolved, if you took the numbers into arbitration to look at what's actually happening in the you will not find, for example, a road case in the commercial court. It's very rare and a lot of infrastructure in this country is actually being resolved at dispute arbitration board, at dispute adjudication boards, DABs, and within commercial arbitration. And you find so much happening outside of the formal court system, and a lot of commerce is actually moving. Would you agree that lawyers, at least a large number of lawyers, have already been tested as adjudicators, and there's nothing really special about the land division of the High Court that it cannot do, with some assistance from the bar, but also the idea of, and I think the conceptual idea right now of, because you've touched on it, but maybe we can touch on it more, how we can get more resource into the court system to reduce the problem that's there, but also if you could also expound on the idea of expanding the choice of arbitration. There's a lot of business in this country that happens outside of formal systems, and a lot of these people would benefit from lawfully binding decisions you talked about tiered arbitration, but I think you really need to build up on tiered arbitration, not so much in the sense of earning from the arbitrator, but in the sense of the wider economy. So I know my question is a bit of a mouthful. Maybe it's also a bit of an answer, but I think the question is, in our view here, we need to think about justice differently. And what can we learn from that arbitration practice? Because I can tell you, maybe I'm wrong, but you're talking about Budadidi Road, you're talking about this road in Mbale, Palisa Kamonkoli Road. I think there's a lot of arbitration around that road. You're talking about the oil roads in Hoima, there's a lot of arbitration around those oil roads. I've not seen those particular arbitral disputes within the court system itself. So maybe you could give us your take on mission-based judges, but also on expanding commercial, like break down for us how we can see more and more lawyers being involved as adjudicators.
Thank you very much. Mission-based. I agree with you that that can be one of the solutions. But it is like having COVID and then you swallow Panadol. You are dealing with symptoms.
Or Covidex.
Or Covidex. At least Covidex, they say that it deals with the virus. But Panadol basically just reduces your temperature. Because the more cases, if you look at those statistics you've read out, as cases are being resolved, others are being filed.
Yes.
So even if you had the mission-based judges, as they're resolving, others are being filed. So you are swallowing Panadol.
But we have a headache.
But you have a headache. So basically, now we need to look at what is the symptom. So that what's the cause? Because we're dealing with symptoms. So what is the cause? In 2010, I was part of a pilot project at the Commercial Court. It was spearheaded by Justice Kiriawiri, where I participated in the drafting of the then Judicature Mediation Rules 2003. Those rules provided that all disputes filed required that you needed to go to mandatory arbitration. So basically it was mandatory
mediation
to attend mediation, but voluntary to conclude. But you had to go there. So, and I was among the first 10 mediators who were accredited at the Commercial Court. And during that time, we managed to resolve through mediation 30% of the cases that existed at that time. But more continued to be filed. And the more our GDP grows, it's almost $60 billion. That time it may have been about 25. The more the disputes are. So the question is, how many mission judges are going to be appointed? The government has done their part. They have set up the infrastructure. They have invested in ECMIS. They have appointed acting judges. The courts are working. The Commercial Court is enforcing awards. If they find an arbitration clause in the contract, they will refer the matter to arbitration. If the parties can't agree, sometimes the judges are proactive. They even direct that a particular arbitral institution appoints. Sometimes the judge names the arbitrator.
Yes.
So they've done a great deal to deal with backlog. But that remains a symptom. I think the cause, in my view, is our culture. We have a culture of fighting. We need to deal with it. And the best way of dealing with it is we need to start engaging. We've started as chartered industry, but we don't have the capacity to go the entire country. We have engaged the Uganda National Chamber of Commerce and Industry. It brings together business people. We've done some capacity building with them to tell them that, look, when you do these contracts, put clauses, tiered clauses, that you first do negotiation, you do mediation, you do arbitration. If we have 50% of all business disputes resolved outside court, we would have dealt with backlog. So it's a culture issue. If we have 5,000 out of the 8,000 ULS members as trained in ADR and aware of the benefits, they will not rush to file a plaint I'll call you, Elison, and say, look, my client has this dispute. Can you call your client and we have a meeting? It's a cultural aspect. And then that matter will not go to court. The matters that are in court, the question will be, is there a culture where you sit and say, let us first discuss this thing genuinely to resolve it? We only sit to sign joint schedule memorandum. We don't sit together to discuss the gist of it. I think the problem is our culture that we need to work with.
Yes, I agree with you. I agree with you. But a large number of disputes actually don't make it to court. I think the larger number, there's, I think, a Hill report. The vast majority of Ugandans are actually not engaging the courts, and they're not engaging the courts not because they have a better option. A large number of Ugandans are shunning the traditional justice system, not merely because they have a better option, but because the traditional justice system does not give them an option. I'll tell you, in land matters, for example, I hope their lordships are not listening, but in land matters, for example, a large number of scoundrels benefit from the litigation process because they grab land and they can use the courts for injunctions and for continuous. Someone goes and superimposes his title on top of your title, and then he goes to court to get an injunction, and he goes to the police station, and the police tell you to bring a court order, and you bring a court order, and they tell you to verify the court. So a lot of people are therefore shunning that system and maybe resorting to other more primitive methods of dispute resolution, including spiritual methods. So people are going to ask the pastor to prophesy about their land and their, and you know, not that we have any problem with the spiritual world, but they are dealing with the Lord's spiritual as opposed to the Lord's temporal. So yes, so I agree that there's an attitude problem. There's also a structural problem, but then you didn't handle the second part of the question, and the second part of the question was how more of us can become adjudicators, and what is the actual, do you have like a numbers story on the success of arbitration here? Like, we're looking at, I gave you, for example, the example of, I've not seen, years ago I used to see them, but I've now not seen injunctions stopping road contracts, electricity contracts. We're seeing a lot of those contracts are right now also formally out. And the worry is, maybe before we got the worry, if you could just give us the story there, because our argument is that in that story there is where you see this. How we deploy them and how we use them is one thing, but allowing the Law Society members to become adjudicators, because you've given some very good numbers. For example, if there are 8,000 members of the Law Society, how can many of them, apart from being gladiators, how can many of them also be adjudicators, not just within arbitration, but within our formal court system? But if we can just start with arbitration, and you give us this bird's eye view of the, if I was to call it the state, you know, as the chairman of the arbitrators, of the Chartered Institute of Arbitrators, you are like the president. Maybe if you can give us a state of the arbitration address, just a bird's eye view.
Thank you, Elison. We need to deal with the fundamentals. Arbitration is a creature of contract. So there must first exist a contract which has an arbitration clause for the 8,000 lawyers to get business. It still starts with us. The question is, Elison, when you're drafting a contract on your laptop, would you put an arbitration clause, or you'll say court? So it starts with us. If many of us put court, you've deprived another lawyer of business, and you've created a backlog. So, but when you're drafting an arbitration clause, it's usually called the midnight clause, because people draft it when they're tired or when they're intoxicated. So they discuss everything to do with money, and then they say this arbitration clause, they just throw it there. Now we need to start with drafting it. And the best example I can give you is the analogy of, if you want peace, you must prepare for war. The Americans know it very well. Before an American man marries, if he's a billionaire, you first sign a prenuptial agreement. He's preparing for war, so he says, you sign. If you're going to divorce you will get 0. So you're here for love, so you sign. So he has, so he's going to have peace, because this woman is not likely to benefit at all from the divorce. So dispute resolution clauses must be drafted first, like prenuptial clauses, that if this contract goes wrong, how do I wish it to be resolved? Do I want to line up in the backlog you've read out? It's a question we need to ask ourselves, 8,000 lawyers. If you don't want to line up, put an ADR clause. And let me give you a simple statistic. In Kenya, one arbitral institution every year makes 450 appointments of arbitrators. 450. One arbitral institution.
Wow.
It's because the Kenyans put arbitration clauses in their contracts. That is why every year 450 arbitrators get business. The courts get business by operation of the law.
By force.
Yeah, they were established by the Constitution and the Judicature Act. That's how they get business. So if we had a Construction Act, for example, which makes adjudication of construction disputes mandatory, you will have 2,000 lawyers dealing with adjudications by operation of the law. If we lawyers, for every contract you draft, you put an arbitration clause, you'll have another 2,000 doing arbitration. So it starts with us. My duty and the Institute is, as much as possible, to disseminate information, to grow capacity, so that we solve this issue. If we are tired of backlog, we need to stop doing things the way we do them. It is often said that a person who sits there expecting change without them changing anything belongs to a mental institution. We cannot resolve backlog, yet we're doing nothing. We cannot resolve backlog if we sit and we say, can we make sure that every contract that we sign, there was a very good attempt which was taken by the bankers when they set up ICAMEC. They came together with the Uganda Law Society, and I really want to thank the people that came up with that idea, Mr. Jimara and Mr. Adrico and his colleagues. They set up ICAMEC. It was a very good thing. And the idea was that these trillions that are locked up should be resolved through that arbitral institution. You know what followed? A certain lawyer goes to court. It was in court for almost 8 years. So a very good thing that should have resolved disputes. So you imagine if all those banking disputes had gone through ICAMEC, if the banks had adopted arbitration clauses, half of this backlog would not be there. So it starts with us.
Okay, if you're just joining us, we have the Judicial Service Conversations. We are with none other than Mr. David Kagwa, the chairperson of the Chartered Institute of Arbitration. About 10 minutes to go. I saw a question from Mr. Derek Kakoza. Said legal education, so that students leave law school with such skills.
Very good question. First of all, it's a policy issue. Who creates the curriculum for the university? Does it go to National Council for Higher Education? That's the first question. But what have we done? Because we should not blame the policymakers. What have we done? We have a young members committee. It's chaired by an engineer. It's called Charles Gavamokulia. They consistently have university programs. They go to the university and enlighten the university students about ADR. So that's the first thing. But secondly, every year I am invited at the Law Development Center to give a talk on arbitration and construction law. But just one event in a year is not sufficient. So I think it has to be a joint effort. It has to be a joint effort that right from university level, we change the way we do things. We take away the concept of gladiators, and we adopt ADR right from first year. So it's a very good question, and we all have to put our heads together in order to have this policy change.
Thank you, Councillor David. Maybe, yes, if you're joining us, you're very late, but You can follow up with this conversation on our YouTube channel, on TikTok, and even listen to the recording. I just have one final question from the audience. This one was asking, I think he has been inspired by discussion to attend the conference tomorrow. So he's wondering, is it too late to register for the conference tomorrow? That's the first question. And then secondly, I think it should be a small business owner who's wondering whether there will be practical dispute resolution or avoidance takeaways or tools for ordinary business or individuals from the conference, or it's only targeted for legal practitioners who do wholesale trades and corporates. Thanks.
It's not too late to attend the conference. You can register and attend it. And secondly, the 1 million shillings we talked about was in respect of a training that we conducted today. And it was a training about dispute boards. And dispute boards are not restricted to only lawyers. Other professionals in the built environment are also members of dispute boards. They're often appointed. So the conference is not just for lawyers only. It's for all people who would wish to get information about running business. Yes.
Thank you. Then just in 1 minute, I think Timothy Semaganda, you have a question just in 1 minute before we close.
Senior colleagues, good evening. Our guest tonight, Mr. Kagwa. Yes, I have 2 questions for you. My first question is, how can a Ugandan arbitration practitioner position him or herself to qualify as counsel in an international arbitration? The number 2 is, are there any regulations for remuneration and taxation of arbitrators' costs? And then lastly is, recently China opened up the International Organization for Mediation. That was on 30th May 2025. And then we see also the ICID, the International Center for Settlement of Settlement of Investment Disputes. So my question is, will there be a sort of forum shopping for international practitioners to choose an arbitration seat? And then what is the cause of the gradual geopolitics? Why is China opening up an arbitration center, and then the World Bank also had already had one? Thank you, sir.
Thank you.
Thank you.
The first question is, how can a lawyer position themselves to do international arbitration? First of all, the choice of being to have an international dispute, you need to tick 3 boxes, and those 3 boxes have 3 C's, and those 3 C's are competence, competence, and competence. You must be competent.
Must be a gladiator.
Yes. Because the world where it has gone, if there is an international dispute and it's a construction dispute, if you're not competent in construction, there is nowhere in the world that you can actually get appointed. So the question is to grow your competence in as much as possible. So we've done our part. But last year we did a training on how to write effective arbitral words. We've done a training today of DABs. You need to attend these trainings to grow your competence. There is no shortcut. The next question is, are there regulations on remuneration? If you look at the answer is yes. The first one is, if you read the Advocates Remuneration and Taxation of Costs regulations, I think the amendment one is for 2018. If you look at that 6th schedule on instruction fees, it talks about instruction fees in magistrates court, high court, and arbitral tribunals. So the amendment included arbitral tribunals. So if you are appearing as counsel in an arbitral tribunal, you can use the 6th schedule. Now, what is not clear is, how do arbitrators charge? Because an arbitrator can be an engineer or an architect. So now the question is, you may go to the charges on per hour, but also it depends on how you drafted that midnight clause. Because if you draft it so well, you can actually say that the arbitration will be conducted in Kampala, and the rules that will govern this arbitration will be the ICAMEC rules. The ICAMEC rules have a schedule of fees, so you can actually incorporate them under the arbitration clause, such that then it's predictable to the parties. Now, the third question is China. It has set up arbitral centers. China is one of the world's greatest economic powers. They don't want to line up in courts anywhere in the world. They have a mandate to build infrastructure all over Africa. They want to connect Africa from east to west, north to south, through infrastructure, roads, dams. They benefit from resolution of disputes quickly. So they're doing it because they do not want to lose their position in the world. It may be a little bit easier to climb up to the level of success, but it's much harder to maintain it. So they wouldn't watch their disputes to line up in the courts. That's the main reason, and that's what we have to do.
Okay, well, thank you so much, David Kagwa, for your wonderful insights. If you are joining us, welcome to the Judicial Service Conversations, and as Alfred informed you, you are late. We are starting to wind up, and as is our tradition here, David, we give you the second last. We'll give you the second last parting shot. So before we invite you, we shall first invite Patience and make an exception among our hosts if Patience can give us her own bird's eye view about the arbitration sector and a few closing remarks, and then we go to David.
Thank you, ELISON, and I appreciate the exception. My closing remarks in respect to arbitration generally, and particularly in Uganda, I would say there are wealth of opportunities for lawyers. I am a lawyer, so I advocate for my fellow lawyers. But what is to be emphasized, like Mr. Kagwa has said, is the need for capacity building. It cannot be overemphasized. So for me, my call to all of us would be to gain as much expertise and experience as we can, because learning does not stop. What you know today may change tomorrow. So for me, it would be take up these opportunities. The trainings are always available. There is a conference. It's a 2-day conference that is coming up tomorrow. But also over a period of time, the Chartered Institute of Arbitrators, Uganda, and Kenya, and the international ones, are always providing trainings and webinars, but also you get to network. And if I don't know you, I'm not going to recommend you. We all know ELISON is the lawyer's lawyer, but he's also the EAT oil and gas practitioner. So definitely I will recommend ELISON. I will recommend Joy, or I will recommend Mr. Kagwa. So let's get out there, get out of our comfort zone, market ourselves the best way we can. But also, let us not be known for a culture of posturing. Let's actually have the necessary competence, expertise, and experience. Because if one client takes a chance on you and you do a terrible job, manyanga, he's not going to recommend you to someone else. And we all know bad news travels faster than good news. So if you get your opportunity to have an instruction, give it your best shot. If you don't have the qualification or the expertise for this particular instruction, consult your colleagues. You can take on, be willing to share. Because if you have a dispute and it's involving structural disputes, you're not an engineer. So be open to learn and say, okay, I'm going to ask Charles, or I'm going to ask Alfred to come in and help, so that you can share the benefits. So I think let's be open to learning, keep learning, but also I think arbitration can, where we have reached as a country, there is no going back. We are only going forward. Like ELISON says, no one can stop reggae. So the reg of arbitration is not stopping. And again, particularly for construction law, the fact that, even Mr. Kagwa mentioned it, the international bodies who largely finance all the projects in Uganda, they don't want to line up in your courts. So they're definitely going to say that you have to have an arbitration clause. Actually, it's put in all FIDIC contracts. So if you don't know the arbitration clauses or how you're going to apply them to this specific project, how are you going to take up the spaces? So let's do our best to make ourselves ready so that when the opportunity strikes, we are able to take it up. Those would be my parting shots. Thank you very much.
Okay. Thank you very much, Patience, for those wonderful parting shots. I see also online Mr. Ivan Okuda, who I think has recently been appointed to the, is it called the Young International Arbitration Group. Alfred, of course, thinks that Mr. Okuda is anything but young. He thinks Mr. Okuda is my age, and he thinks that when Mr. Okuda graduated, they also 2 universities and now they are 50. But take it from me, Mr. Okuda is actually a very young man, and he represents young people globally. Of course, Alfred could also be young. You may not know that Alfred is the Secretary General of Young People on the East African Law Society, elected by the Uganda Law Society. Yes. So there was a petition about age. There's a petition about age, but fortunately for him, there's an injunction currently stopping all matters of the Uganda Law Society. But over to you, David. Just if you give us your parting shots and your closing argument for your closing submission on this issue of arbitration, and how we can navigate the new frontiers in Africa's evolving landscape.
My parting shots. There is enough for all of us. There is enough for all of us. My parting shots are that there is enough for all of us, but there is not enough to satisfy our greed. So if we grew our numbers to 10,000, cutting across all professionals, there will be enough business for all of us, not in Uganda, but worldwide. So that's number one. Then number two, we have a duty not to belong to the mental institution. The things that have not worked, we should not continue doing them. We need to sit down and have dialogue with all the players in the justice sector, and we come up with solutions. Mission judges is one of the solutions that you raised. As to why mandatory mediation was removed, I think it was working. But when we amended our civil procedure rules, the judicature mediation rules were repealed. But when we were having those rules, we had 30% success. Maybe we need to reintroduce mandatory mediation. We need to have the Construction Act. And then also, we as practitioners, we need to include ADR clauses in our contracts. Those are my parting shots. Thank you very much, ELISON, for inviting me to this very important talk.
Thank you very much, David. I think it has been truly our honor to have you. And I think that nobody who has listened will regret having listened. I think you have been educative, you have been entertaining, you have been informative, and we are grateful to you. We are grateful to you because you've reminded us of some of the basic things. You've challenged us in terms of culture, you've opened our eyes in terms of opportunity, you've broadened our minds in terms of scope, and you've given confidence to many of the people who are listening with regard to the capacity of the Ugandan lawyers, that you are the chairman of the Chartered Institute of Arbitrators, that there's a big conference happening in this city, and that you have time to come to talk to your professional colleagues the night before that conference, not so much to pitch the conference, but to pitch the concepts, to pitch the ideas, to bring what will be in the room to those of us who will not be in the room. And that is giving, and we are grateful for your giving. We are grateful also for your growth from 5 to 250 members. I don't know if Alfred is a member of the but I'm sure Reina is. I'm sure Patience is. I am very suspicious that Joy is about to become. And I think Alfred also is considering. He's just worried about how he'll balance it with his many young lawyer initiatives. But truly we are grateful. I think that conversations like these are important because we have to move the conversation about legal business, dispute resolution, the judiciary, that our profession should not be the stumbling block of that attempt to reach $600 billion in GDP growth. And so these sort of conversations are important. But what we have learned is the growth, and why I was talking about the growth in the organization is because it's not just a growth in numbers. It is a representation of a growth in faith. That people are moving and voting with their feet and with their wallets. When it comes to the great backlog of Uganda, I believe strongly that backlog is one of the big challenges of our judicial system, and I think we should fight it like a war. But I also think that there are other challenges that are on the horizon, and I think you raised them brilliantly. We have 3,000 people that finished LDC this year. That means we have 3,000 new people on the roll of advocates. We have, or getting onto the roll, starting the process of entering the roll. We have thousands more every year who are going to be joining. The nature and state of legal business is going to be changing, but also our ability to serve the public is going to be changing. And ideas like arbitration, adding yourself a qualification, joining an institute are some of the things that I think many people should hear. We must not be the area or the land or the home of lamentations. We must be the place of acts, as they say. And we must grow. But we can only do that if we continue to have these sort of conversations. So in summary, thank you very much, David. We are grateful.
Thank you.
We are humbled. Yes. Thank you very much, Patience. We are humbled. And we are very grateful. I bring apologies from Mercy. One of our course is Mercy Makabai Chemutai. I deliver her apologies. And I'm very grateful to everyone who has joined us. I thank the Uganda Law Society Handle. They have really been very supportive in this conversation. And I think everyone who has joined us. Now, what we usually do here is these people they wanted to bring a new culture of asking people for their favorite songs. So we don't play them. We want to hear them so we can particularly avoid playing them in the end. No, but I'm only joking. We always we always start this conversation with Nobody Can Stop Reggae. for obvious reasons. The reason being that nobody can actually stop reggae. So reggae has to play. And then we usually end it with another song. This song came, of course, as a result of popular public demand. And it's really about me. Unfortunately, David, you have to endure listening to this song, because really, the song is about me. When they were singing it, for sure, they may not have necessarily had me in mind, but many colleagues, when they hear the song, they just really, I come to mind immediately. As you can see. So please, ladies and gentlemen, wherever you've joined us from, we are grateful to you, David. Good morning to those who have joined us from wherever you joined us from. Good morning, good afternoon, good evening, and good night. And now the song, which is a dedication from many friends to me, nothing other than we had 513 people listening.